Hello everyone, and welcome to Internet Law Review. For today's story, we have the United States Supreme Court decision of Knick versus Township of Scott, Pennsylvania. This is a case dealing with the Takings Clause of the Fifth Amendment to the Constitution. This provision of the Constitution provides that no private property shall be taken for public use except with just compensation. This provision allows the government to take property for public use, such as a new fire station or a new road or other public use, and it requires the government to provide compensation when they do that. But the question is, who can hear the case? Under current law, only the state governments can hear the case. There has been suggestion that state governments do not fully take into consideration the seriousness of these cases because it is the state government who often wants to do the taking themselves. So the state government has an incentive to say that these takings are proper and perhaps not give all the compensation that's due. Under the case law prior to this, a person could not go to federal court. So the question here today is whether or not that decision should be overruled. Should a person be allowed to go to federal court in the first instance, or should they only be allowed to be heard by a state court? Let's see what the Supreme Court has to say. The Township of Scott, Pennsylvania, passed an ordinance requiring that all cemeteries be kept open and accessible to the general public during daylight hours. Petitioner Rosemary Knick, whose 90-acre rural property has a small family graveyard, was notified that she was violating the ordinance. Knick sought declaratory and injunctive relief in state court on the ground that the ordinance effected a taking of her property, but she did not bring an inverse condemnation action under state law seeking compensation. So under the Takings Clause, if the government wants to take your property, they have to sue your property, and that would be a condemnation action. An inverse condemnation action is where the person themselves is the plaintiff. They're arguing that the property has already been taken, and so they're suing the government for that. And so that's the difference between a condemnation action, where the state is the plaintiff, and an inverse condemnation, where a private person is the plaintiff. Although the Township of Scott, Pennsylvania never admitted as such in any of its court filings to the best of my knowledge, I have a slight suspicion personally that this whole thing is a bit of a mistake. I think that when the Township of Scott, Pennsylvania wrote all cemeteries, they didn't have this fact situation in mind. So that goes to show that when you're drafting law, you should be a little bit more careful. I don't think they really meant that for a private home with a small graveyard, that should be open to the public. I don't think that was what they had in mind, but that's what they wrote. And so here we are. Perhaps a mistake, but nevertheless, the Supreme Court's got to deal with it. Let's read on. The township responded by withdrawing the violation notice and staying enforcement of the ordinance. Without an ongoing enforcement action, the court held, Knick could not demonstrate the irreparable harm necessary for equitable relief, so declined to rule on her request. Knick then filed an action in the federal district court under 42 U.S.C. 1983, which is a statute that basically says any violation of federal or constitutional law can be heard by a federal government court, and that's how one of the main ways you get to sue a state for violating your constitutional rights, alleging that the ordinance violated the Takings Clause of the Fifth Amendment. The district court dismissed her claim under a prior U.S. Supreme Court case, Williamson County Regional Planning Commission versus Hamilton Bank of Johnson City, which held that a property owner must seek just compensation under state law in state court before bringing a federal taking claim under Section 1983. The Third Circuit affirmed, held, a government violates the taking clause when it takes property without compensation, and the property owner may bring a Fifth Amendment claim under Title 1983 at that time. In Williamson County, the court held that, as relevant here, a property development federal takings claim was premature because he had not sought compensation through the state's inverse condemnation procedure. The unanticipated consequence of this ruling was that a takings plaintiff who complied with Williamson County and brought a compensation claim in state court would, on proceeding to federal court after the unsuccessful state claim, have the federal claim barred because the full faith and credit statute required the federal court to give preclusive effect to the state court's decision. So the United States Supreme Court is pointing out a tension that exists between two of its own prior cases. In Williamson County, the United States Supreme Court held that you could not go to a federal court without first going to a state court. But 20 years later, in San Marino Hotel, the United States Supreme Court also held that a federal court had to give full faith and credit to a state court decision. So the interaction between these two decisions is clear. Because you could not go to a federal court without going first to the state court, and because a state court's finding were fully bound to the federal courts were deprived of any power to hear these kinds of cases because of the tension between these two cases. So is this a situation that calls for some resolution? Let's read on to see what the Supreme Court has to say. This court has long recognized that property owners may bring Fifth Amendment claims for compensation as soon as their property has been taken, regardless of any other post-taking remedies that may be available to the property owner. The court departed from that understanding in Williamson County and held that a taking gives rise not to a constitutional right just to compensation, but instead gives a right to a state law procedure that will eventually result in a just compensation. The state departed from that understanding in Williamson County and held that a taking gives rise not to a constitutional right to just compensation, but instead gives a right to a state law procedure that will eventually result in just compensation. 2 years later, after Williamson County, however, the court returned to its traditional understanding of the Fifth Amendment, holding that a compensation remedy is required by the Constitution in the event of a taking. A property owner acquires a right to compensation immediately upon an uncompensated taking because the taking itself violates the Fifth Amendment. The property owner may, therefore, bring a claim under Title 1983 for the deprivation of a constitutional right at that time, which is to say, as soon as the taking occurs. Williams County's understanding of the Takings Clause was drawn from Russell Haas versus Monsanto, where the plaintiff sought to enjoin a federal statute because it affected a taking, even though the statute set up a mandatory arbitration provision for obtaining compensation. That case does not support Williamson County, however, because Congress, unlike the states, is free to require plaintiffs to exhaust administrative remedies before bringing constitutional claims. Williamson County also analogized its new state litigation requirement to the federal takings practice under the Tucker Act, which deals with compensation for federal government contracts. But a claim for just compensation brought under the Tucker Act is not a prerequisite to a Fifth Amendment taking claim. It is a Fifth Amendment taking claim. Williamson County also looked to Parrott v. Taylor, but Taylor was not a taking case at all, and that analogy from due process context to the taking context is strained. The poor reasoning of Williamson County may be partially explained by the circumstances in which the state litigation issue reached the court, which may not have permitted the court to adequately test the logic of the state litigation requirement or consider its implications. Respondents, which in this case would be the state of Pennsylvania, read too broadly statements in prior opinions. The taking clause does not provide or require that compensation shall be actually paid in advance of the occupancy of the land to be taken, but the owner is entitled to a reasonable, certain, and adequate provision for obtaining compensation after the taking. Those statements concerned requests for injunctive relief, not monetary relief, and the availability of subsequent compensation meant that such an equitable remedy was not available. So by way of explanation, let's talk a little bit about equitable remedies. Equitable remedies are distinct, or at least were distinct, from legal remedies. Under common law, there used to be two sets of courts, one for legal remedies and one for equitable remedies. Legal remedies came from the statutes, and equitable remedies came from a sense of justice or sense of fair play. Some of these remedies are duplicative of each other. But a general proposition that's long been held is that if you have a legal remedy, it's not proper to give equitable remedies. Equitable remedies are only available if the legal remedies are not available. So if you have a resolution at law, that's your resolution. By long-standing case law, injunctions, which are an order for someone to do something or to stop from doing something, are considered an equitable remedy. So therefore, if you have a legal remedy, such as monetary compensation, you cannot get the injunctive relief because the legal remedy is available, and that's what the court is talking about here. Let's continue reading on. Simply because the property owner was not entitled to injunctive relief at the time of the taking does not mean there was no violation of the taking clause at that time. The history of takings litigation provides valuable context. At the time of the founding, there was usually no compensation remedy available to property owners, who could obtain only retrospective, backwards-looking damages, as well as an injunction ejecting the government from a property going forward. But in the 1870s, as state courts began to recognize implied rights of action for damages under the state equivalents of taking clauses, and here they're referring usually to state constitutions which have their own provisions for state law in addition to the federal law constitution, they declined to grant injunctions because property owners had an adequate remedy at law. Congress enabled property owners to obtain compensation for takings by the federal government when it passed the Tucker Act in 1887, and this court subsequently joined the state courts in holding that the compensation remedy is required by the taking clause itself. Today, Because the federal and nearly all state governments provide just compensation remedies to property owners who have suffered a taking, equitable relief is generally unavailable. And as long as an adequate provision for obtaining just compensation exists, there's no basis to enjoin government action effecting a taking. The state litigation requirement, which required someone to adjudicate this in state court, of Williamson County is overruled. Several factors counsel in favor of this decision. Williamson County was poorly reasoned and conflicts with much of the court's taking jurisprudence. Because of its shaky foundations, the rationale for state litigation requirements has been repeatedly recast by this court and defenders of Williamson County. The state litigation requirement has also proved to be unworkable in practice because our later decision in San Marino's preclusion trap prevented taking plaintiffs from ever bringing their claims in federal court, contrary to the expectations of the Williamson County Court. Finally, there are no reliance interests on state litigation requirements. As long as post-taking compensation remedies are available, governments need not fear the federal courts will invalidate their regulations as unconstitutional. Reversed by a traditional 5-4 split, Roberts writing for the majority opinion on behalf of the conservative end of the court, and Kagan writing a dissenting opinion on behalf of the liberal end of the court. While this is a pretty significant change in the law by explicitly overruling a prior United States Supreme Court decision, it's unclear to me at this time what impact this will have in practice. If a person whose property is taken goes immediately to federal court and files a 1983 claim on that basis, as long as there is an available state remedy, the federal government should not intervene. But as the Supreme Court points out, almost every state does have state remedies. It is therefore unclear what distinction this will make in practice. If there's available state remedies, and there are, then the states will continue to hear the matter, one would presume. There's nothing really for the district court to do. I suppose in the odd example where there isn't a state remedy, the federal government could order the state to fashion one, but that's not going to be true, particularly in real estate, where this is more of a common factor. As a result of this, I'm not clear what distinction this is going to have on the ground. Previously, someone had to go to state court before going to federal court, but then couldn't go to federal court. Under the current scenario, someone can go to federal court right away, but as long as there's an available state remedy, the federal court probably shouldn't act. And the state court is in the best position to interpret state law, and there's nothing preventing them from doing so. So sure, you can file your 1983 action, I guess, but if the state has a process and it's going through its process through its normal course of events, it doesn't appear like the federal court is supposed to do anything here. So as a result of all this, while it is a pretty major change in law, it's unclear to me at this time what, if any, distinction this will have going forward. However, federal courts are generally viewed as more favorable to property rights than their state courts, which obviously have some interest in the state being able to do what it wants to do. So to the extent the federal courts are going to get in substantively, this should be a boon to property owners. I also think that this decision is somewhat an indication that the court is interested in reversing other decisions dealing with property law, most notably Kelo versus New London, which said that private property could be taken by the government for another private use, which is a deeply controversial decision. I think this decision seems to indicate that that might be overruled in the future, but we'll have to see if this is the case that will later give rise to that or not, and only time will tell. But until later, my friends, that is all. I hope you're well. Cheers and goodbye.